Imagine you're a single parent. You've just spent the last couple of days having a wonderful time with your child. Now they're spending some time with their other parent, and you're relaxing at home, enjoying some quiet time for yourself. Suddenly, there's a knock at the door. It's the police, and they're there to arrest you for abusing your child. You know you've done nothing of the sort, but they say they have doctor's reports and sworn statements. What would you do if you were falsely accused of abusing your own child? That's what we're going to talk about today on Fathers Are Parents Too. Welcome to Fathers Are Parents Too. We're here today with attorney Peter Firpo, and Mr. Firpo specializes, among other things, in representing people who have been falsely accused of abusing their children, both physically in general and also sexually molesting them. Peter, what on earth made you go into such a heart-wrenching and just tough field?
Well, it is a very tough field. Someone came in, they had their case. A lot of the description was the way you had presented it, which is a fairly common scenario, and we were fairly successful in that case, and then another case came in with the same kind of a sad story, and one thing led to another, and eventually those kind of cases filled my caseload to the exclusion of the others.
Now you say it was similar to what I described, and then another similar case came in, and I'm wondering, is there sort of a general profile, a typical way these things run? What's the general pattern if you're going to end up facing an allegation, a false one, that you've abused your child?
There is a format to these kind of cases. Often the parents have a great deal of difficulty sharing custody of the child. Somebody will have an agenda getting you away from the child, and at some point they stumble upon this idea or this technique to get you out of the kid's life, and they make in some fashion the accusation surfaces, and it's very effective because the usual reaction of the court system is to cut you out of visitation. If the order doesn't say no contact, then the order says supervised contact only. So
one of the typical profiles then, as you mentioned, divorce. It comes up in the case of a divorce. Are there other sort of standard ways, warning signs, besides that there's a divorce going on? Is it always a parent against a child, one parent accusing the other?
It does occur in non-divorce custody situations. We see it occur very often in those cases. In the other scenarios, a child can be in conflict with their parent, and as a result of things they've learned either on television or as a result of school programs, become aware of the power that they have by making such an accusation. And you see this typically in another format. For instance, is a young teenager, 13, maybe 14, 12, who is resisting parental authority, and by then they've learned enough, and they make the accusation, and that wipes out whoever is trying to control them, just wipes them out from any control over them.
Now, a parent can make an accusation against another parent, or a child against a parent, but one would certainly hope that just that accusation is not going to be enough to bring the legal system to bear or the criminal justice system to bear on the accused person. And how does the system then get involved and get to the point, even though there isn't any abuse going on, where these people are being arrested or prosecuted or cut off from their children in the family court? How can that happen?
You're thinking that the system would want to investigate and have other objective evidence before filing a criminal charge and bringing somebody to court. And sadly, that is not the case. The criminal process can occur simply on the word of the child. The law is that you don't have to have any corroboration. If the child is credible, or if the child is believed by a jury, for instance, that is sufficient to convict. It doesn't require any outside objective evidence to support a conviction. And you go to an appeal, and they'll say that if they believe the child and the jury chose to believe the child, they're not going to overturn the conviction.
Let's talk about the role of the mental health professional, because I've seen in other cases, we've had Carol Marks on here who talked a bit from that perspective. The sense I get is that they can play a very important part as these things are brought to bear against a parent in terms of validating the alleged abuse even where it doesn't occur. And I think that you've had some experience in that regard with I think you said a case that was similar to McMartin, in fact, where there were dolls or something involved. And how does that whole thing play out?
Well, sadly, or fortunately, the mental health professional doesn't have that much of an impact in criminal cases, although I am familiar with one where they had a devastating impact. But you see them most often where they can impact the case is in the family law, where the burden of proof is quite a bit different. It's a preponderance of the evidence that is beyond a reasonable doubt, or in even juvenile court. And what you will see, the mental health professional who wants to use these anatomically correct dolls, which are dolls that are I mean, conceptualize this. You're going to a kid, and maybe she's under 10, and you give her a doll, and what do children do with dolls? They play with them. But they use this doll as some kind of a device to supposedly acquire facts, or they'll give them to, say, a 4-year-old. And these dolls are made, they're cloth, and they're made with a hole where the anus would be and a hole where the vagina would be, and they're made with a penis and a boy doll. And then the kids play with them, and from that they come to conclusions that this doll play means they were molested.
Wouldn't it make sense that a child would immediately gravitate towards the feature of a new doll that they never saw in a doll before?
Well, these dolls came out, and they were used, and then finally the other mental health professionals decided that maybe we should study whether what these mental health professionals are saying this represents is something scientifically provable. And the dolls have fallen in disrepute as a result of those studies, which have shown that it's just play.
And yet how many people were convicted or cut out of their children's lives based on that faulty...
How many people are in prison today based on faulty data from supposedly doll play? How many people aren't with their children in a family court situation as a result of faulty data from doll play?
Well, now what about the other part of the medical profession? Again, when we were speaking before, you mentioned what would be considered hard medical evidence that's used to convict or to dissect a father or mother out of their child's life, where it turns out that the evidence, while there, just didn't mean abuse at all. And what that I would assume still goes on. No one has yet studied doctors and said that they're not valid for...
Well, what you're referring to is where you'll get a medical professional to make some statement that this is a sign of abuse. And where that came from is that in the, say in the late 70s, when they were trying to find, to prosecute child abuse, the idea came up, well, the medical profession needs to come forward and help to stop and curb and protect these kids and support these kids. So sadly, again, some medical health professionals came forward and said, well, from my experience as a clinician, I've seen this indicator, which I believe indicates child molestation. And so you get 5 or 6 or 10 or 12 of these indicators that people have talked about. And then they go on the lecture circuit and teach other doctors, if you see this sign, it's probably a molest. And if the kid comes in and says, I was molested, and you got the redness, you put two together, you can testify it's a sign of molest.
I actually read a study where they had set up a control, and the researchers had set up a control and studied doctors. They gave them a made-up case file and certain quote-unquote evidence and asked the doctors to assess whether they felt, in this particular case, it was sexual abuse of a very young infant or toddler. And the entire physical evidence was one small black curly hair found in the diaper. And the vast majority of these clinicians who were the subject of the study, based on that, said yes, a molest probably had occurred, and I was astounded.
Well, it's part of that mindset that they were taught that they need to come forward and help in this area. And sadly, again, it's unbelievable to us that there were no real studies, scientific studies, controlled studies of what a normal child should look like up until 1988-89, when John McCann put his study together. And so one would think that with all the hysteria about child molestation in the prosecutions that we would have had some normative studies. There were no normative studies up until that time. And then ever since then, the medical witnesses have been less significant, but only because there's been scientific data to say what you guys are saying is not accurate.
Okay, I'm going to ask you something that I'm sure you get all the time, and I don't mean to put you on the spot, but as I said, I'm sure you get this, so you're ready for it.
We'll find
People
out.
have got to come up to you at times and say, Pete, what if even one person that you represent really did it? How can you defend these people that are accused of such heinous crimes against our children?
Well, the role of a defense lawyer in this sense is not to make the judgment call, but to see if there is valid proof that something terrible has happened to this child. And it is so difficult to call that it would be inappropriate for, I think, a defense attorney to put himself in the position of God and make the call that, oh, and I feel in this case this person's a child molester. And I don't think it's appropriate to say, well, if I save one child from being molested, because then we start throwing the baby out with the bathwater. I mean, then we start cutting off all relationships between fathers and children, or mothers and children, whoever's being accused.
And isn't it also true that children who go through the process with a false accusation are damaged in different ways, but in some cases just as much as ones that are really being abused, because they're still subjected to the exams and to...
Well, I would think that that has been addressed by Karl Marx, and it's no question that if you raise a child with the belief system that they were molested, what a horrible stain to put on them for them to carry through life, when in fact they weren't. And we know that, well, we teach our kids history. Your history is you broke your arm at 2 years old. Your history is you were molested at 18 months. And when in fact they weren't, then they grow up and then they can share with each other, oh, I was molested when I was 2 years old, and in fact they weren't.
What an awful thing.
What an awful thing to do to a child.
It's terrible. We have some questions from our audience,
We do?
so let's go. Yes, we do. Yes. Hi.
Hi. In these cases, I've heard that quite often the protestations of an innocent father are generally ignored. I'd like you to comment on why it is that you think that the people just won't believe me when I tell them I didn't do it.
That's a good question.
It's one of the quirks of this allegation, child molestation, for instance, that if you were to come to your circle of good friends and say to them, I was accused of bank robbery, you know, 99% of them would say, no way, I know you, that couldn't have happened. You go to that same circle of friend and you say, I was accused of molesting my daughter over the weekend. What, 60%? Who knows? 50% might just lean back slightly and start to get worried about your contact with their children. It's one of the few places where your good character doesn't seem to come into play, or people won't treat it with incredulation at first. So I don't know if that answers your question. It's just the quirk of this particular allegation. It's one of the few that you're guilty until you prove you're innocent. And even then, I don't know if you saw that thing on TV the other day. They did a survey, and still 70% of the people said they still were suspicious. Even if you were found not guilty at a trial, they would still have suspicion of the accusation.
That's incredible. Yes, did you have a question?
Yes.
Stand up, please.
I'm wondering how the parent who's accusing the child can live with that, knowing what the child has to go through, and what is their reasoning behind it?
We feel that, or I feel that much of this is fueled by hatred. This is just simple anger. And they don't appreciate the impact on the child until, of course, it's much later. It's too late. But right then and there, when they see that father squirm, or say it's the father, and they see the impact on that relationship, and they see the pain that that person's suffering, that's good for them. That's what they want. And it's not until too late that they realize that they've gone too far. And many people don't realize the reaction of the system. Many accusers or persons who have manipulated the accusation are surprised at the reaction of the system. They think maybe counseling, therapy, supervised visitation. But when the person's cut out of their life or goes to prison, they've gotten into the hole so deep they can't pull out, so they don't call it off. They're afraid to call it off.
Pete, do you think it's possible, too, that maybe some of these parents making these accusations might believe them even though they shouldn't? They sort of have this, gee, I'm going to be the shining knight, you know, on the white horse and save my child from this, you know, awful molester. They really believe it somehow, or?
Some of the first preliminary questions we ask, or I ask when I'm doing an intake interview and trying to start the investigation, start the defense of the case, I find the history of the person, of the adult, for instance, who's with the accusation. And I find quite often that they have a history of being molested when they were kids. And there's that reaction. They are ready to believe it much more so than I think somebody who was never molested, because they know it's happened to them. And so now I've let it happen to my kid, and they're told that this comes in cycles, and then with the cycles repeating itself, so that it all feeds into their mindset, and you know, it's fertile ground, and it grows.
Is there any quantitative difference in dealing with a case if the accuser believes it versus if they're just doing it maliciously, or does it sort of end up playing out the same way anyway?
Well, it plays out the same way. It's because even if you ultimately get your mental health professionals and everybody under the sun to say, well, we really don't think this happened, then the person's fallback position is, well, I'm so relieved. I'm glad they weren't molested, and I was only protecting them, and this wasn't nothing malicious on my part, and that's it. Everybody they walk away, back to status quo, except the other person's kind of ruined.
Yeah, yeah. So you had a question?
Yeah. As it happens, just a couple of weeks ago, a good friend of mine was falsely accused of domestic violence. He was thrown in jail, $50,000 bail, felony abuse charges. Actually, he's lucky because his wife has known manic depression problems, and she's been hospitalized. And actually, she attacked him. Now, as I say, he's lucky. He will probably get custody. But what happened is he was ordered that he could not see his children. There were no allegations of abuse with involving the children whatsoever. He's got two kids, 10 and 14. And I would gather you'd say that's a fairly common thing. What I'd wonder is there any legal justification for that restraining order against him seeing his children? And can he expect to get his children to testify in a hearing that they would like to see their father?
Is this in California?
This is actually I referred him to you. He's in Lafayette.
Well, the answer to your second question, part of your question first, you can get your children to testify if they choose to. I mean, there's nothing legally can stop them from being witnesses in your behalf. So that can happen. The first part of your question was, does this happen? Help me here, Ann.
The first part of the question was, why is it the case that even though...
Because the first part of the question was the reaction of the legal system, the no contact, cut the person off. The charges, especially in light of the O.J. case, these are politically charged, politically incorrect charges. A judge is going to take the safety first approach. I'm not going to be written up in the paper of being light on this stuff. I'm not going to lose my job. I'm not going to get thrown out of office next election because somebody runs against me because I'm light on these spousal abuse people or light on these child abuse people. So I'll just go safety first. That's easiest for me. Cut off all contact. So you're asking me, is there legal justification? I think there's a political justification. I don't think there's a legal justification.
You have a question?
Yes. These false allegations of abuse, are they isolated cases that happen once in a blue moon, or do they happen once in a while, or how frequently do they actually come up?
Well, unfortunately, it's like asking the doctor how many people are sick in the world, and they say, well, everybody, because everybody I see are sick. But I think it's a lot. It's a lot. Anybody wants to put actual statistics, they're just playing games. It occurs quite a lot. It's a very effective tool, especially in a domestic relations case, a very effective tool for neutralizing the non-custodial parent and for getting more custody time or just getting them out of the life altogether. So can I quantitative, do you want to say 50%? Some people can say 40, some can say 80. Who knows? Is it that important when it happens to you? The impact is devastating.
Let's talk for a minute about when it does happen to you. In reading some material out there, some of which I think you may have written, in fact, they talk a lot about what a father particularly would do when he's first accused and he goes into the system and he'll be offered the chance to plea bargain and he thinks, well, gee, this is the way out because then I'm not guilty. And yet there seems to be this whole sort of mindset that if he keeps denying that he did it, and it may be because he didn't, then he still did it and he's in denial and then he can't be with his kids. So how does that all work? Well, obviously it doesn't work,
right.
But
the only slack you're going to get out of the system is if a jury says you're not guilty, because the minute you enter any kind of negotiated plea or settlement of the case, you're going to be referred to counseling. And the minute you walk into a counselor's office and they say, well, what's wrong with you? And you say, nothing's wrong, I took this plea or this deal to stay out of prison, they'll say, well, then we can't help you and you're in denial. And as long as you're in denial, you're a risk to your child. As long as you're a risk to your child, you can't be with your kid. So until you get out of denial, you know, I guess you can't be with your kid. So it's a catch-22. It's a loop you can't get out of. And the only way to get out of it is to not get into it in the first place. Fight the cases, win the cases, and try to get your relationship back with your child.
now, is there a set of steps that you would advise people to take, given the benefit of the hindsight you have, so they don't need to come into their own set of hindsights, to let people be alerted to certain things they can do to protect themselves to ward off this false allegation ever coming?
Well, I think you need to get a good mental health history on any significant partner that has a child that you're going to be involved with, because it does seem to crop up in those situations where they have a history. If there's an animosity situation between the parents, you need to be careful. You obviously need to do some of the obvious things. You need to not, you know, people used to take showers with the kids when they were up to 2 or 3 years old. You know, you need to stop. And that used to be innocuous up until the divorce. Then it became very sinister. You need to watch your bathing habits with the kid. Are you giving the child a bath? You know, if that's, or especially the toilet training. Are you involved in toilet training? You just need to really put a wall between you and the child. It's a sad situation, but it's the reality, because all those parenting activities are given a sinister sexual twist in court. So what used to be changing the diapers now becomes, you know, sexual touching. That, just as one example, or potty training, you know, where the child doesn't wipe themselves correctly, and then have you wiping your child.
And that can be twisted around to be
Sure, that's a sexual
molest.
touching. That's nothing to do with wiping the child. You just want to touch the kid.
That's awful. Yes?
Why is it so easy to believe that a man is much more capable of that than a woman?
It's that old gender bias. Women are the nurturers, the care providers. Women can wipe the little girl's vagina when she's 3 years old to make sure it's clean, and that's nothing sexual. A man does it. It's got a different twist. It's the sexual bias that's just inherent in the system, hasn't been shaken out.
What can be done to get some relief for these people that are facing this? I'm not hearing you talk at all about what happens when the jury does say not guilty. What happens to the person who brought that accusation? Earlier you said they just walk away and nothing's happened, and I just can't believe that. I mean, isn't that wrongful prosecution or perjury, or I mean, something's got to be done to make it harder to do this.
Well, you know, in California, they've passed this statute which permits custody to be altered if there's been a false accusation, and that can be a factor in deciding who gets custody. But and I think it's a great law, and maybe it might intimidate some people. But I think the reality is, I shouldn't say this, but I think the reality is that and I'm just going to use the mother as an example because that's generally how I see it anyhow, the cases I see it. All she's got to do is say, I didn't know, I thought it was in best interest of my kid, I was protecting my kid. She wraps herself up in that whole cloak, and it's going to be rare that any judge is going to hammer her. What you can hope for, I think, what's going to work out is you get back to your status quo. If you had 50-50 at the beginning, and then you went down to 0, and then you beat it back, it's going to be back at 50-50. For the judge to say, you're the alienating parent, you messed up here big time, you're on the supervised visitation list, it can happen, but it'll be the rare occasion that does happen. And it's going to require a lot of documentation. You got to have your tape recorder running, you have your tape machine on your telephone running, you have your witnesses there who can show the court that there's this constant banter and pattern against the child. or you know, against you in front of the child, which ultimately a judge says enough's enough, and you get your mental health professional to say this can't go on, you got to stop. They don't stop. Eventually, you prove your case. But that's, you know, who's got that kind of money? Who's got that kind of time? Who's got that kind of luck?
Now, if you're on the receiving end of one of these allegations and it's in the process of a divorce, a custody dispute, presumably you already have an attorney, and it's your family law attorney. Am I safe in assuming that you should not entrust this kind of defense to someone who does not specialize specifically in that area, such as yourself? You call yourself a criminal defense attorney, and I know that family law is practiced very differently. So would it be safe to assume that the first thing someone should do is still consult someone such as yourself or someone in their area who is familiar with criminal law as well, even if it's not a criminal prosecution?
Right. I mean, criminal defense of these kind of cases, but what I have evolved into, many of my cases are family law child custody cases. I approach them with the same way I would approach it as if they were a criminal law case. They have to prove it, the different burden of proof. Unfortunately, what we see in the family law sector is that the cases are turned over to the mental health professional for feedback, and that just doesn't work, because once the mental health professional gets involved in the case, then a duty to the child arises. Up until that point, you know, they had no duty to make the right call or the wrong call. Once they get involved in the case, they have the duty to make the right call. Well, if they call it wrong and the kid gets molested, who are you going to sue? So then, I don't want to be sued if I'm a mental health professional, so I'll just say, let's, for everybody's safety's sake, let's put Dad on supervised visitation until the kid's 18. I mean, I'm being facetious, and yet not so facetious, because it does occur. I mean, that is just the mindset. So getting them out of the mental health profession is almost impossible once they get hooked in. So you've got to approach these cases. You can't just refer them to the mental health professional, because that's the slide down the tubes.
Well, we're about out of time, but before we say goodbye, why don't you tell us where you are, so if people happen to be in your area and are unfortunate enough to have an accusation but fortunate enough to be near you, where would they find you?
So these plugs that we get to do?
There you go.
I'm up in Benicia. I'm in the phone book, and it's a 707 area code in California.
Okay. Well, thank you very much for joining us, and be sure to join us next week on Fathers Are Parents Too.